It will be recalled that the governors of the 36 states of Nigeria had approached the nation's apex court to set aside the executive order of President Muhammadu Buhari on the ground that the federal government was pushing its responsibility of funding both the capital and recurrent expenditure of the state high courts, Sharia Court of Appeal, and the Customary Court of Appeal to the state governments. They held that the Executive Order 10 was a clear violation of Sections 6 and 8 of the 1999 Constitution, which made it mandatory for the federal government to fund the listed courts. They argued that they have been funding capital projects in the listed courts since 2009 and asked the Supreme Court to order the federal government to make a refund of $66 billion to them. However, last week Friday, the Supreme Court of Nigeria, in a 6-1 split decision, declared unlawful the Executive Order 10 issued by Nigeria's President Muhammadu Buhari. The Executive Order 10, which was signed by the President in May 2020, provides financial autonomy to both the legislature and the judiciary. The apex court also dismissed the 66 billion naira suit filed by the state governors against the federal government. Joining us now for an in-depth analysis of the apex court judgment is Liborous Oshoma, a lawyer. Welcome to the show, Liborous Oshoma.
My pleasure.
Thank you for joining us.
Always my pleasure, and happy Valentine's.
Happy Valentine's Day.
Well, I've read some comments by some senior advocates saying that there are no winners or losers in this particular case. In your view, are there winners?
Yes,
Are there losers?
There are.
Is it correct to say there are no winners and losers?
No, I would not. It's not correct to say that there are no winners and losers. There are indeed winners, and there are losers also. I would not want to be politically correct to say that there are no winners, because the first winner for me are the Nigerian people. Executive orders usually, if are not orders made to correct or to enforce provisions of the Constitution as regards duties of other organs of government. They are usually directed at the executive. And so we also have the courts. If there are any infraction on any provisions of the Constitution, it behoves on the courts to interpret such infractions one way or the other. And then there are responsibilities placed on people, on us. Trying to sound politically correct to say, excuse me, to say that there are no winners and there are no losers, for me, I do not think so. I also think that what this also had done is to shift the responsibility of holding our governors accountable to the rest of us, and especially also to the NBA. Because it is easy to say the governors would not want to obey provisions of Section 121, subsection 3, because that provision had consistently been observed in breach. And that's why the president, in his wisdom, decided to introduce Executive Order number 10 to compel the governors, excuse me, to compel the governors to comply. But the court had said, well, look, this is way outside your powers. It is not within your powers to use executive orders to compel, the compliance of the provisions of the Constitution. So Nigerians have gained from that, because if you allow that to go unnoticed, what it means is that you can have a dictator tomorrow who will just come up and begin to dish out executive orders to either implement sections of the Constitution or even violate sections of the Constitution. So, and that's on one side. Secondly, on the other side, now the president also knows that there is a limit to issuance of his powers as regards the issuance of executive orders. And that's why I would look at it from that angle of, winners and losers. Like we say in law, the law is what the court says it is. And thank God we are all lawyers here. So.
Yeah. It did seem a bit odd, this notion that...
Is that Austinian positivism?
Yes. This notion that a constitutional provision, the grand norm, the Constitution, needs to be buttressed in any way by an executive order. But can you take us through the proper use of executive orders and where they are in order?
Yeah, executive orders, the introduction of executive orders was actually usually directed as the enforcement of the powers of the executive. Issuing executive orders to, let's say, the army to carry out a particular functions that is, domicile or resident within the powers of the president. If you remember and it's actually started from America, the executive order compelling mass burial for soldiers killed during the Second World War, First World War. The executive order also stopping discrimination against people of color in the American army. And then why this executive order had become so rampant here in Nigeria, because if you remember under Trump, Trump was known to dishing out executive orders, and even though those executive orders, as many as they were mainly directed at enforcing the powers of the president, because also it is not within the powers of the Congress or the legislature to overrule or override those executive orders. But in this case, now, anything that comes to Nigeria, once it's here, we just, want to abuse and excessively use them. And so, in this case, now having to use executive orders to enforce or implement the provisions of the Constitution, or even undermine the provisions of the Constitution, for me, it's ordinarily a no-no. No matter how good an executive order is, it cannot take the place of a written law and cannot also contradict. It is the lowest rule in the ladder of laws. And so not to now talk about using an executive order not to even implement the provision of a statute, an honorary law. You're talking about the ground norm now. And so that's why the Supreme Court, was emphatic in that position that, no, Mr. President, you're going, way outside your powers. And why some people are saying it's there are no winners, there are no losers, is the fact that the Supreme Court also had said, look, these courts are state high courts. And so, operating a federal system of government, we don't operate a filibuster system of government where the federal government takes it all and the federal government dishes out or distributes as they want. In one breath, you are asking for true federalism. In another breath, you are saying, we've spent all the money we've spent on capital projects in the various state courts and Sharia Court, including Customary Court, that it should be the responsibility of the federal government. I also think that that's also very wrong on the part of the governors.
Okay. There was a particular wrong that Executive Order number 10 was meant to correct.
Yeah.
You recall that in 2021, the Judiciary Staff Union of Nigeria,
yes,
they went on strike for about 64 days. The National Judicial Council had to appeal to them. They had to sit down and sign what they call a memorandum of action. With state governors. And the whole point was that, look, they were not getting their salaries and allowances because these governors were sitting on, monies, allocations meant for state judiciary and the state legislature. And then the president came with this executive order to compel the state governors. That problem, I guess, still exists, yeah, in spite of the Supreme Court ruling.
Yes. Because,
these governors, is there any guarantee that they will not continue to observe sections 81 and sections 121 in the breach? So what do you think can be done to cure that problem? Do we need to amend the Constitution further? You recall that the Juson was insisting on financial autonomy, yeah, for judiciary because they bear the brunt of the recklessness of the governors.
What this has shown is that you have people who are not fit to be leaders in Nigeria, people who cannot obey, the letters of the law that they sworn to uphold. And two things. One, we can amending the Constitution is a tall order, is a long process in most cases. And so you find out that you now go back and forth with the same governors. And in some cases, some of the State House of Assembly members are beneficiaries of this amendment, will also reject such amendment because a lot of them have been known to be stooge of the governors. And now that the court has said the letters of this executive order is in conflict with the provisions of the Constitution. What should we do? The court also didn't go further to state what should be done in the circumstance. And I think that's why I said that responsibility should be on the bar now. And the members, because the judiciary cannot go to court to challenge or to compel enforcement or implementation or compliance by the governors. It behoves on us as lawyers, as members of the bar, to also ensure that this section is challenged and enforced in the interim. And then that executive provisions of the executive order, that's also, I have a problem. If I say, let's amend the Constitution to include that provisions to ensure that any governor that refused to comply, the money should be deducted by the Accountant General, because that was the content of the executive order. That might also be giving, too much wide powers to the government at the center. And if you have a government, a dictator at the head, that would be arbitrary. So for me, the court's interpretation in most cases might come to the rescue in as far as the section 131 sub 3 is concerned.
121?
121, sorry. Section 1213 is concerned. Because really, in a situation where the governor, you're holding down the money that is meant for an arm of government, a distinct arm of government, and nothing is done, nothing is said. And that's why you see, everybody shouts, people do not understand the import of the Independent Electoral Commission in all of this. If you have a transparent electioneering process, it becomes very difficult for people who will violate the law to be at the ends of affair. People will know that at the end of the day, you always come back to the electorate, and you'll be asked questions, and that's where compliance with the provisions of the law become very sacrosanct. But when elections are anything goes, and anybody can win an election, they get there and they observe the laws in breach, and you do nothing about it. And that's why we need to consistently have our eyes on the umpires that is going to conduct the election for us, so that people will understand. Once you have that transparent process, a governor that violates the provisions of the Constitution as regards the independence of an arm of government, especially when that governor is also looking for independence, definitely something needs to be done at the pool. But when we can't do something at the polls, then we need to have recourse to court, which is what the Supreme Court has said resoundingly, that look, you need the courts, this is the business of the court. It is not for the president to unilaterally interpret a section of the law and then now spell out penalties. But then in the long run, we can now begin to talk about amending the Constitution to spell out penalties for default, because it's a provision of the law that is like, it's vague. It's just there. There are no consequences for defaults. And so when the law does not spell out consequences for default, I think, in the interim, the court can, act as a stopgap. But in the long run, let there be amendments so that we can have consequences for it. But not that amendment of, oh, look, the president will have to breathe down the neck. Let the responsibility be on us.
Well, we hope that you actually do discharge that responsibility.
Definitely. That's why you hear people say, oh, the Ganifa enemies of this world. I tell people, you don't have to wait for a Ganifa enemy. You can be Ganifa enemy. If you are not a lawyer, you can sponsor a lawyer to take up a public interest matter and approach the court for interpretation. You don't need to wait for people to do it. If we understand that this responsibility rests on all of us, and also most especially the bar, there's needs for the MBA to issues like this, take them up and come up with a team of lawyers, senior advocate, or junior advocate, as the case may be, and then ensure that this matter is fought to a logical conclusion. But that is how you develop democracy. Democracy cannot be developed by, some person sitting down somewhere and dishing out executive orders to implement the provisions of the Constitution.
So my question for you, at the time when that executive order was signed by Mr. President, there were some who raised questions of its constitutionality. There were others who said this was President Buhari's approach to soft restructuring, in quotes. Is that what he was thinking? Do you think that's what he was trying to achieve here?
No, for me, if you're talking about restructuring, it wasn't a way of, for me, that was, it was an illegal way of addressing a legal problem. And I do not think it was a solution to addressing the persistent issue of restructuring. But if we're talking about the issue of restructuring, then it should be a constitutional thing and not just a stopgap. And a lot of senior lawyers also have written articles on that executive order that it's clear illegality and it shouldn't be allowed to start, no matter how good or well-intended it is, because at that time it addressed a need that was an immediate need. And so a lot of people, looked the other way. But also the executive knew what they were doing, because it was like testing the depth of water with 1 foot. So if this is allowed to sail through, then, they might probably have gone the whole hog in other instances. And so that's why for me, if you're discussing restructuring, then let's sit down, look at the content of the Constitution, and then begin to, address the issue of restructuring one after the other, and not using executive, because also, mind you, we cannot use executive orders to address the issue of restructuring. It is a no-no.
Well, thank you for that. I was even wondering what on earth is soft restructuring, but I wanted you to address that.
Okay, I mean, you've made some comments on the judiciary within the purview of this particular ruling. But there's also local government autonomy involved in this matter. And the governors hide under Section 7 and Section 8 of the Constitution to say that local councils are like appendages to the state governments. But they extend their terrorism, if I may use that phrase, under this creation of what is called the Local Government State Joint Accounts Committee.
Yes.
And, these committees will charge in many states administrative costs and all of that. At the end of the day, these local councils don't get money that is passed through the state governments. Don't you think that beyond the constitutionality of the ruling in this particular case, that there are indeed an urgent need to address this state and local council joint accounts committee, which some people have been saying should be scrapped? But to scrap it, you have to amend the Constitution.
Yes, you see, in all of this, there is no way we can avoid going back to this document. Some people had said that we do not have a constitution properly so-called. If you remember, there were days we had Ibadan Native Authority, Lagos City Council, the Port Harcourt City Council. These were local government, and they function even far better than some of the states that you have today. And so when people tell me, oh, look, the local government completely should be scrapped because of what the governors have turned them to. And then the Constitution also had not helped matters. The Constitution just guarantees a local government administration. Even though the Supreme Court had interpreted that in the case of Ekiti State Governor and Algon, that the state governors do not have powers to sack a democratically elected local government officials, because by virtue of the Ekiti State local government administration law, it gave these governors the powers to sack an entire local government council elected, democratically. And the Supreme Court nullified that law. But yet, you still have situations where it's either they refuse to conduct local government election and then man local government with administrators, like it's happening in my state, in Edo State, caretaker committees. And then you ask yourself, just imagine that the president of the Federal Republic of Nigeria decide to impose caretaker committees in almost all the states in Nigeria, we will not be seated here today. So our gaze should also consistently be on our state governors. The way we focus our attention on the federal government, I do not think that we also take our time to focus our attention on our state governors like that, because the state governors are worse than the federal government. Because what they will not take, half of the things they will not take, that's what they do at the local government level. And then I always go back to election. Election period, the state governor would nominate House of Assembly members. And so the House of Assembly members, in some cases, there was a time in Cross River State, the House of Assembly members will meet on Sunday to deliberate on the activities for the week. And then the executive members of the House will take the deliberation to the governor for approval. And then he approves, okay, this should go, this shouldn't go. Because some of these members knew how they became House of Assembly members. They are just appointed by whoever the governor is. And that was what led to even the amendment in the constitution on whether there should be direct or indirect primaries. So that let everybody who wants to be a candidate in an election go to the field to slug it out and get nominated. But now we're still battling with that. Even the issue of transmitting election results electronically to be assented to by President Buhari is a different thing. The issue of having credible people in INEC is also another one. By a man who says, look, INEC had disappointed him on three different occasions. One would have expected that as soon as the president came on board, the first thing should be, let us find a way to ensure that you have credible people in INEC. That's not the case. And when you do not have credible people in INEC, election becomes, just a all-commerce affair. And once you have that, funds meant for local government, the local government is the government that is closest to the people. This road right in front of my office is being constructed by the state government today. Meanwhile, that is ordinarily a local government road. So local government have been reduced to salary-paying agency. It is the court's interpretation cannot help this matter. We will need to go back to amending the constitution to ensure that governance starts from bottom to the top and not from the top to the bottom. Consistently, every month, they all rush to Abuja to collect funds. And then the funds that are meant for the local government that are supposed to be under them, they legally hide under what they call a joint account. And then when the local government sign away their rights to the state governor, like it's happening in Lagos State, and most other states are copying. The functions of local government are spelled out in this constitution have been taken over completely. Signages and advertisement, cemeteries and the rest have been completely taken over by the state government. And yet you still have local government to register bicycles. Licensing ordinarily, because as at the time the registration of bicycles was the function of the local government, it was presumed that was the highest means of transportation. Now that you have cars, trucks, and the rest, that should ordinarily also be the function of the local government. But here, we reduce local government to nothing, and then some of us are meant now to question what the duties of the local governments actually are and what they are doing, what their functions are. And it's a way of giving a dog a bad name in order to hang it. And I think consistently, we cannot move forward, if you like, amend the Electoral Act 10 times until we get back to this constitution to actually separate the functions and empower our local government. We'll just be dancing around because we have reduced the entire country, Nigeria, to a big local government where the president is the local government chairman. And that is why everywhere you are in Ekak Pamre, you are calling on Mr. President to come and help construct the road. You are in Erimugokware, you are calling on Mr. President to come and help address the pothole or the fish pond. You are in Anegbete, you are calling on Mr. President.
All these places you are mentioning on the map of Nigeria?
Yes, they are on the map. You are in Arugungu.
Sure?
Yes.
Okay, I know Arugungu.
You are in Arugungu, you are calling on Mr. President. Ordinarily, you should be calling on your councillor or the president. I was in a meeting in Miami, Florida, and Nigerian delegation, federal government delegation, came to meet with the Miami-Dade County representative. And all of the introduction, everybody they introduced were Board of County Commissioner Chairman, Board of County Commissioner this board. And I told myself, I said, these are all councillors. And you have our ministers and House of Assembly, senators here, meeting with councillors. But when it comes to Nigeria, the councillors are relegated. They are not seen, not even with a governor. And until we go back to our constitution to amend and empower local government, we'll continue to have this problem. The court won't be able to solve it.
Yes, and we wonder why there was such low voter turnout in Abuja over the weekend. But aren't we in a bit of a quandary at this point? Because we do need the state houses of assembly if we want to effect any kind of constitutional amendment. And their governors can just simply tell them, to decline. That
is why we are pleading with Mr. President to assent to the amended Electoral Act. That's a right step. That's where we should start from. Because looking at the State House of Assembly as presently constituted, nothing good will come out of it because they have been selected, not even nominated, selected by the governors. And they would consistently do the bidding of the governors, including the caretaker committee at the local government. So, but when the Electoral Act is assented to, and then to a large extent, we can have, confidence and hope in the electoral process. And that's the only way people will now say, yes, I know my vote will count. Just the same way we're able to monitor the Edo State election online. okay, yes, even though there will be manipulations, it would be reduced and minimized. Once you have that, that confidence will gradually return to the process, and people will have faith in the process. It's not a 100-meter dash, it's a marathon. And the earlier we start now, the better for us. And look at local government, and not just the Abuja municipal election, every local government election, even in Lagos here, the turnout is usually very massively low because it is intentional. The government makes local government unattractive. They make them look, they are just there because the constitution says they should be there. They really don't do anything anyway. And so, the functions of local government, instead of protesting to Koshofe local government, for example, or Balende local government, or Ikoyi local government, we want to protest to Abuja or protest to Alausa because Alausa had made it so that local government are non-functional. If we understand that all these duties, all these responsibilities that government owes, that the local government should be our first point of call, and our laws actually enables us to look at those people that go into our public office to ensure that the laws are obeyed, then we won't need to begin to... people will take local government election much more important than even the state government election. If you remember, those days, there were days when there were times. In the Second Republic, you had cases like the Oloyo and the Speaker Bende State House of Assembly, Benson Alegbe and the state governor. You hear the governors, the Speaker, the House of Assembly challenging the authorities of the governor. You hear State House of Assembly challenging the powers of the governor, just the same way the Senate would challenge the execution of the powers of the president today. But these days, you hardly hear of anything of such. Now, the powers of the State House of Assembly to financial autonomy, spelled out in the Constitution, had been consistently trampled upon by the state governors. And what did the House of Assembly do? They sit down there with their tail in between their legs and then, do nothing about it. Even the judiciary, we are lucky in Lagos. Go to some state like Benue, even Delta and Edo. The magistrates in those places are suffering. They are going through hell. In some cases, magistrates will have to take buses to villages to attend to court. Yes, I've spoken to some of them. And yet, it is the financial autonomy for the judiciary that would ordinarily enhance this. So when we see governors donate cars to judges, we clap for them. It shouldn't be so. That is an indirect way of compromising the judges.
It is.
When you see governors donate cars to magistrates, it's as if they are doing them a favor. It shouldn't be. It is the rest of us that should insist that, no, this is an aberration. It is not for you to donate cars to or dish out cars to governors or build houses for them. It is for the judiciary to be responsible to these people so that they will truly, be unbiased.
Okay. Well, one other thing the judges said is that the president acted ultra vires.
Yes.
Now, the powers of the president are constitutional. Section 5, Section 130, where he's called the Commander-in-Chief of the Armed Forces. So you could assume that inherent in that title is the power to issue orders.
To the armed forces.
However, the same president of Nigeria, or the administration generally, this is about the first time we're having executive orders in Nigeria.
Yes.
Where did those executive orders come from? Because the Constitution does not expressly mention anything like executive order. And in what particular sense has the president acted ultra vires? Has he usurped the functions of the legislature? Or the Supreme Court was concerned that there was a tendency towards dictatorship?
Yeah, I think it is not first and foremost, let me start from the usage of executive orders. Like I said, it's an American system of government that we have copied. And being a president, operating an American-style presidential system of government, so it is typical for us to want to copy anything from there, whether good or bad, whether in their laws or not. Because over there, it is not just the way it is here. It is inherent in the president's powers to issue executive orders to, the armed forces and then also to members of the executive, agencies under the executive. Yeah. It is inherent in the powers of the president in their constitution. But here, So because it is normal over there, and so when Trump came and started dishing out executive orders, as soon as President Buhari came, a lot of people, it was the goodwill that President Buhari enjoyed that made a lot of people just look away with these executive orders. And the court, I think the court took a back seat to, look at these issues and discover that, one, there was tendency to gravitate towards dictatorship, and then also usurpation of the powers of the courts. Because matters, if there are violations, it is inherent in our constitution that, a violation of the provisions of the law or determination of the interpretation of the provisions of the law, it's domiciled in the powers of the court. And but the situation where you now use an executive order it's like an addendum to section 121, sub 3, to say this any money standing to the credit of state houses of assemblies and the judiciary in the federation account or the consolidated revenue account shall be charged directly to these agencies. But however, in the event that any governor fails to comply with this order, the accountant general shall deduct that fund and pay directly to. So it's like using an executive order, to amend a section of the Constitution. And so that's why the court has said, look, no, look at this. Ordinarily, if you look at it, you say, oh, it's fine, fantastic. After all, it's enhanced the law. But the court, protecting the ground norm, says, no, look, this is like amending the Constitution. This is what traverses your power. You cannot sit down and amend the Constitution without it going through the process of amendment. And then also, you cannot sit down and take over the job of an adjudicator who feels where you feel that a section has been violated. So in those two areas, usurping the powers of the legislature and then also taking on the cloak of the judiciary, those are areas I feel that that law had violated or had gone out of the powers of the president.
Well, there was a dissenting judgment. And the dissenting judge was saying, oh, this is constitutional. But yesterday, when I brought it up with Chief Robert Clark on another program on this channel, he said, in fact, we should not even mention that dissenting judgment at all.
That is why.
And that, in fact, I should not mention the name of the judge.
That is why I didn't bother. That is why I didn't bother to even go there, because even senior lawyers, junior lawyers, party members and non-party members are unanimous on this. For the first time, including supporters of the government, are unanimous that yes, because this is not about the president, because this president will leave office someday. And so it is the legacy, the precedent that he sets that others might follow. And you never can tell who will come after him. And so for somebody, a judge, to sit down and say, oh, look, I see some sense in this. For me, I wouldn't really want to, for posterity and for the sake of his integrity and credibility, I wouldn't want to dwell on him.
Have you all decided to help him cover his shame or what's going on here? I want to talk about the second leg of the dismissal of that 66 billion naira suit. What's your perspective on that?
Yeah, like I said, it is like in one breath saying that we want, fiscal federalism. In another breath, you're shifting the responsibility, saying, no, these courts belong to you. Take them. But they are our courts. But every capital project on the court should be carried out by you. And so the Supreme Court in its wisdom said, look, no, you can't approbate and reprobate, in the same voice. And so that was why the Supreme Court felt, look, there's no need for you to be asking for. It's like saying that every fund spent on the state legislature, on capital project for the state legislature should be borne by the federal government. I've never really seen them. I wonder how. If we were in Senate societies, for that alone, some of the attorney generals would have been resigning by now.
So I wanted to ask you, what is the quality of the legal advice that chief executives at state level and federal level are actually getting?
Do they even get advice? You remember Obasanjo told us that I can appoint you, you can advise me, but it behoves on me to take the advice or not. And so a situation where attorney generals, unlike those days, when you appoint attorney generals, they are attorney generals properly so-called. Now it's all about political appointment. And so in some cases, you hardly hear or see some state attorney general. You begin to wonder, who is the attorney general? Who is advising this man? And that's why, look at our federal attorney general, for example. There are some cases our federal attorney general, Baka Malami, senior advocate, with all due respect to him, there are some cases you listen to him, you now begin to ask yourself, is this the kind of quality of advice that the president is getting? If this is the kind of advice the president is getting, then don't wonder we're in this problem that we are in. And then lastly, and that's why even this government, when they were in opposition, consistently advocated for a separation of the office of the Attorney General and the Minister for Justice. Let the Minister for Justice advise the executive. The Attorney General, in cases like this, where there is a violation of the Constitution, if we had an Attorney General whose office also was elected, he probably would have, taken such matters up with the state executive. But that's not the case here. So the Attorney General, rather than seeing himself as the chief law officer of the state to protect the state, will first and foremost see himself as an appendage of Mr. Governor or Mr. President to protect the governor. And then whatever happens to the citizens of that state or the president is immaterial to him. And it's a shame. That's
another constitutional amendment we should look at.
Exactly.
Yeah, well, it's been on the table since that the two positions should be separated. That an Attorney General or Commissioner for Justice cannot be at the same time be a law officer and at the same time be a politician.
Can't work.
But anyway, part of the problem, why I guess some of these chief executives don't take advice, is that politicians, most of them are bathroom lawyers. By the time they take part in election petitions 2 or 3 times, you've not seen them quoting the Constitution.
Yes,
and overriding the Attorney General.
Yes. But when you're an Attorney General that knows his onion, you sit down and insist that I had a situation where I declined a brief because the client already knew the process. It's a land matter, and he came to me and was already telling me,
case law
lawyer, this is what you should do. In the case of Idudu and Okumagba, this is what the law said, this is what you should do. And I said, no. The current position of the law is, he said, no. I said, okay, in that case, since you are the lawyer, please just go and do your case. So that should be an Attorney General that knows his onion. But because of the benefit that accrues, and in some cases, resignation in Nigeria, people need to understand why people don't resign. Not because, in some cases, even the benefits are not there, but because of fear for their life. Because when you resign, it's like, a thumbs down for that government. So people will go to town to say, even the Attorney General has resigned.
Okay.
So they wouldn't want to hear that.
Looks like we have to go. I would have loved to ask you whether there are other executive orders. Because in this case, the Supreme Court looked at the substance rather than the form of executive order number 10. But there are other executive orders before we go to number 10. But, not enough time to go into that. Thank you very much, Liborous.
My pleasure. With time, we'll always get all of them.